CBS News correspondent Natalie Brand is joining us right now live outside the White House. And Natalie, what do we know about why President Trump wants to be at those arguments?
Yeah, Mugo, he first mentioned that he would be attending in his comments to reporters yesterday afternoon or evening. And recall that he had floated the idea of attending the arguments in the tariffs case, but ultimately he did not. We know that that case did not go in his favor. I think attending the case signals the importance of this case to the president himself and his administration. He's argued that birthright citizenship, as it's been interpreted, is, quote, one of the many great scams of our time. And as Katrina so articulately laid out, he argues, the administration argues, that the 14th Amendment had to do with babies of formerly enslaved individuals, accusing people in modern times of exploiting it, including, quote, what he's called Chinese billionaires. Of course, challengers, critics point to past precedent and federal law, saying that this order that he signed on day one of his second administration.
Hey everybody, Jack here, full energy, no filter. Trump made history as the first sitting president to attend Supreme Court oral arguments, but the moment quickly became a political firestorm. What unfolded inside the chamber has created an unforgettable image that his team will struggle to explain. The setting was the Supreme Court chamber, where Trump's administration was arguing for its most constitutionally ambitious immigration policy, the effort to restrict birthright citizenship. No cameras are allowed in the Supreme Court chamber, which means there is no definitive visual record of what occurred. But multiple reporters inside the room described what they observed from their seats, and their accounts paint a picture that Trump's defenders are struggling to counter. The Washington Examiner noted that Trump was occasionally closing his eyes. The Wall Street Journal said his attention appeared to wane as the hearing went on. The Daily Beast described the combined picture as another dozy dawn moment in a high-stakes hearing.
It is illegal. So really, this case now before the U.S. Supreme Court tests one of the cornerstones of, as we know, one of his key pieces of his agenda, which is, his crackdown on immigration, and the implications, again, as Katrina laid out, could be sweeping.
Yeah, and I want to also talk about something else that the president is doing later today. He's addressing the nation tonight about this ongoing war with Iran. What can we expect there?
Yeah, well, the White House announced this primetime address shortly after the president told reporters that the U.S. would be leaving Iran soon, predicting it could be another 2 to 3 weeks. So we'll have to wait and listen and see if he lays out kind of an exit strategy here or next steps on the ground, which critics, particularly those on Capitol Hill, have accused the administration of not doing to this point. What is the plan moving forward? What is the update with these negotiations as we approach that deadline that he had previously set for this coming Monday, April 6th. In a new interview with Reuters this morning,
Fox News tried the briefest spin available, saying he closed his eyes for brief times but looked alert and focused overall. The White House said he was listening attentively. Those two descriptions, occasionally closing eyes and attention, appear to wane from the Washington Examiner and the Wall Street Journal on one side, alert and focused from Fox and the White House on the other, represent a split that cannot be easily resolved. The unprecedented nature of Trump's presence at the argument itself deserves analysis because it is genuinely historically significant regardless of what occurred while he was there. No sitting president had previously attended Supreme Court oral arguments. The tradition of presidents staying away from Supreme Court proceedings while those proceedings are ongoing reflects a specific separation of powers norm that the executive branch.
News this evening. Today, President Trump became the first sitting president to attend Supreme Court arguments as the justices discussed birthright citizenship. And the president did not seem pleased by what he saw. CBS's Natalie Brand is live in Washington tonight with the arguments. And Natalie, how the justices quizzed the attorneys.
Yeah, a lot of intense questioning, especially directed to the president's solicitor general, who is arguing in favor of this executive order. On the other side, you had the legal team for the plaintiffs in this case representing families who would be impacted, and that includes a Honduras citizen with a pending asylum case who currently lives in New Hampshire.
ACLU National Legal Director Cecilia Wong pumped her fists, leaving the Supreme Court Wednesday after presenting her argument that President Trump's executive order seeking to end birthright citizenship is unconstitutional.
I am confident that the court is going to turn back this president's effort to radically rewrite our 14th Amendment rule of birthright citizenship.
President Trump attended part of the arguments in person, a first for a sitting president.
Having filed its legal position through the Solicitor General, steps back and allows the judicial process to proceed without the physical presence of the most powerful person in the executive branch. The norm exists for a specific reason. The Supreme Court is supposed to decide cases on the merits of the legal arguments, not on the political significance of who is in the room. A president sitting in the chamber during argument for his own administration's case changes the dynamic of the proceeding in ways that are difficult to fully measure. The justice's awareness of being watched by the subject of the litigation creates a pressure that the normal absence of presidential attendance is specifically designed to avoid. Trump's attendance was clearly intended as a signal of how important the case is to him personally and to his administration.
He posted after, quote, "We are the only country in the world stupid enough to allow birthright citizenship." The president's team argued before the court that right does not automatically belong to children born in parents who are in the country illegally or temporarily.
It operates as a powerful pull factor for illegal immigration and rewards illegal aliens who not only violate the immigration laws, but also jump in front of those who follow the rules.
But justices, even some of the court's conservatives, appeared skeptical of the administration's argument during questioning.
It's a new world. It's the same Constitution.
The conservative majority court ruled against the president's global tariff policy earlier this year. And while the justices had tough questions for both sides Wednesday, legal experts say they did not appear to be highly conflicted.
Maybe what they were struggling with is how to write the opinion, not necessarily how it's going to come out.
Lower courts have found the president's executive order illegal, pointing to precedent from the late 19th century.
Are you asking us to overrule, then, our cases, one of which said that a child of illegal aliens?
That is a legitimate political communication. But the tradition it departed from exists because the justice's independence from executive pressure is a feature of the constitutional system rather than a formality. The intended story was, Trump shows up to fight. The story that actually emerged, Trump closes eyes during disaster hearing, is the gap between the intended message and the received message that is specifically damaging to the communications goal the attendance was supposed to serve. If Trump had not been there, if the Solicitor General had argued the case in the normal way without presidential presence, the story would have been about the hearing itself and whether the justices were receptive. With Trump present, the story became about what reporters observed him doing during the hearing, combined with the assessment of how the hearing went legally. Unprecedented attendance amplified the coverage of both his apparent attention lapses and the legal setback by making his presence and his engagement into a specific and trackable part of the story. The second part of this story is what happened to his case. The Daily Beast called it a disaster hearing. Multiple justices across ideological lines pressed the government's lawyer on how the administration's birthright citizenship plan could square with more than a century of precedent recognizing birthright citizenship for nearly all children born on American soil. The session was described by attendees as bruising for Trump's side. The combination of the two, a historically unprecedented presidential Supreme Court appearance during which reporters described apparent attention lapses for a case that was receiving skeptical questioning across ideological lines, is the specific combination that produced the disaster hearing framing and the legally and optically on-the-ropes political picture. The birthright citizenship case and what happened in that argument deserves as much attention as the attention lapses story, because the legal substance of what the justices said is the specific reason reporters are calling it a disaster hearing. The 14th Amendment to the United States Constitution, ratified in 1868, contains the Citizenship Clause, the provision that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That language has been interpreted for more than a century, including by the Supreme Court itself in the 1898 case involving the child of Chinese immigrants, to mean that virtually all children born on American soil, regardless of the citizenship status of their parents, are American citizens at birth. That is birthright citizenship. The doctrine is sometimes referred to by its Latin name, jus soli, the law of the soil, and it means that citizenship follows from birth in the jurisdiction rather than from the citizenship of the parents. Trump's executive order sought to restrict birthright citizenship for children born in the United States to parents who are themselves in the country without legal authorization or who are on certain temporary visas. The legal argument for the executive order is that the subject to the jurisdiction thereof language in the 14th Amendment means something narrower than it has historically been interpreted to mean, that children of undocumented immigrants or temporary visa holders are not fully subject to American jurisdiction in the relevant sense and are therefore not covered by the citizenship guarantee. The legal argument against the executive order, the one that more than a century of legal precedent and the 1898 Supreme Court decision supports, is that born on American soil is born on American soil, and that the historical interpretation of the Citizenship Clause has consistently recognized that nearly all births on American territory produce American citizens. The skeptical questioning from justices across ideological lines is the piece that most directly explains the disaster hearing characterization. When legal commentators describe a hearing as going badly for one side, what they typically mean is that the justices are asking the kinds of questions that reveal skepticism about the central arguments. Questions that probe the weaknesses in the legal theory, that press the government's lawyer on precedents that seem to cut against the administration's position, and that suggest the justices are struggling to accept the argument being made. Analysis of the hearing noted that several justices pressed the government on how the birthright citizenship plan could be squared with more than a century of precedent. That specific pressure on precedent is the most significant kind of pressure in constitutional argument because the Supreme Court operates through a system in which prior decisions create strong expectations about how future cases will be decided and in which overturning well-established precedent requires a specific and compelling justification. An executive order that attempts to implement a reading of the 14th Amendment Citizenship Clause that a century of precedent has consistently rejected is in exactly the position where skeptical questioning about precedent is the most damaging possible judicial response. And when that skepticism comes from across ideological lines, not just from the liberal justices, but from justices appointed by Republican presidents who might be expected to be more receptive to the administration's restrictive interpretation, it signals a deeper problem with the legal argument that partisan judicial alignment cannot explain. The watching and closing eyes combination produces the specific political picture that makes the story more than two separate incidents. A president who attends the Supreme Court argument for his most constitutionally ambitious immigration policy in an unprecedented demonstration of how important the case is to him, and who then appears to reporters to drift and close his eyes during the argument in a hearing that is going badly for his side, is generating a specific political image that encapsulates the simultaneous legal and personal vulnerabilities we have been documenting. The legal argument is failing. The physical presence meant to demonstrate personal investment appears to have resulted in public attention lapses in the case at the center of it. Birthright citizenship, the 14th Amendment, 100 years of precedent, is the most constitutionally fundamental of all the legal battles because it touches on the definition of who is an American at birth rather than on the scope of executive regulatory authority or the limits of emergency powers. The pattern connection to the falling asleep coverage matters for understanding why this specific incident generated the attention it did in the context of the broader second-term narrative. In previous coverage, we documented multiple incidents across multiple event types: the Oval Office maternal health event, the Memphis press conference, the pharma industry briefing, the cabinet meeting, the presidential fitness test signing. The Supreme Court hearing is a qualitatively different venue for the same pattern, not an informal or long-running event in a comfortable setting, but the formal chamber of the Supreme Court of the United States during the highest-stakes legal argument of his immigration agenda. If the pattern of apparent attention lapses occurs even in a setting with that level of formal significance and that level of personal presidential investment, as signaled by his unprecedented decision to attend, the pattern's pervasiveness across contexts is more established than any individual incident alone could establish. The Dozy Dawn characterization in the Daily Beast connecting the Supreme Court incident to the previous incidents through the same framing is a specific covered signal that this is being understood as pattern confirmation rather than isolated incident. The Fox News attempt at spin, "He closed his eyes for brief times but was alert and focused," is worth spending time on specifically because of what it reveals about the political sensitivity of the incident. Fox News does not typically describe Trump's courtroom or hearing behavior in terms of eye closing at all. The fact that Fox felt it necessary to acknowledge the eye closing and immediately characterize it as compatible with alertness and focus reflects the awareness that the eye closing reports from multiple outlets, including the Washington Examiner and the Wall Street Journal, both conservative-leaning, were too widely documented to deny. The specific formulation, "closed for brief times, alert overall," is the spin that is available when complete denial is not possible, but damage mitigation is still required. And that the most Trump-favorable major media outlet felt it needed the alert and focus qualifier alongside the acknowledgement of eye closing is itself a data point about the political significance the incident was generating. The birthright citizenship case's broader constitutional context connects to the judicial constraints thread we have been tracking throughout this series. We have covered the emergency restraining orders that blocked the family reunification program terminations. We covered the tariff ruling that included Trump's own appointees in the majority against him. We covered the deportation confrontation and the judge's direct engagement with administration officials. The birthright citizenship case is the most constitutionally fundamental of these judicial battles because it challenges the administration's reading of the 14th Amendment itself, the constitutional provision that defines who is an American by birth. A skeptical reception from justices across ideological lines in that specific argument is the judicial warning light that the administration's most ambitious constitutional reinterpretation is in trouble even in the court that Trump's appointments were supposed to have moved in his direction. The two pieces, the attention lapses and the legal setback, produce a political picture that is more significant than either alone. The first thing to understand is the specific political significance of the unprecedented presidential presence decision and what it revealed about expectations versus reality. Trump's decision to attend was clearly intended to demonstrate personal investment and to generate coverage of him being physically present for the most important immigration legal battle of his second term. The intended story was Trump shows up to fight. The story that actually emerged, Trump closes eyes during disaster hearing, is the gap between the intended message and the received message that is specifically damaging to the communications goal the attendance was supposed to serve. The political lesson is the same one that applies across the broader second-term communications pattern. The moves designed to project strength are generating coverage of weakness when the underlying reality does not match the intended message. The second layer worth sitting with is the legal stakes of the birthright citizenship case and what a Supreme Court loss would mean for the administration's immigration agenda. If the Supreme Court opposes the injunctions blocking the executive order or rules directly that the administration's reading of the citizenship clause is constitutionally incorrect, it would be the most significant single legal defeat for the administration's immigration program. Not because it ends all immigration enforcement, but because birthright citizenship is the most constitutionally rooted protection in the immigration space, the one grounded directly in the text of the 14th Amendment rather than in statutory interpretation or executive discretion. Ruling that the executive cannot restrict birthright citizenship by executive order, that doing so requires a constitutional amendment rather than a presidential executive action, would establish a bright constitutional line that limits the executive's ability to reach the parts of the immigration system that the Constitution itself protects. The skeptical reception from justices across ideological lines in the oral argument is the early signal that such a ruling is possible, and the implications of that ruling for the broader second-term immigration agenda and for the administration's theory of executive power would be as significant as any of the other judicial setbacks we have documented. The optical combination and what it means politically is that both of these things happened in the same moment and in the same event. Trump's approval ratings are at historic lows. His Iran war is unpopular. His inflation numbers are devastating. His military leadership is in an unprecedented exodus. His former cabinet officials are calling him a threat to democracy. His courtroom behavior in other proceedings has been characterized as self-defeating by legal analysts. Into that accumulated political picture, this event deposits a specific image: a president sitting in an unprecedented setting for the most constitutionally significant case of his immigration agenda, with reporters describing attention lapses during a hearing that legal commentators are calling a disaster. The image is the accumulation made visible in a single moment. It is not what the unprecedented Supreme Court attendance was supposed to produce, but it is the documented political image that the moment actually generated. The administration and its supporters have arguments about both the attention lapses story and the legal picture that deserve acknowledgement. On the attention lapses, the White House said he was listening attentively. Fox News described him as alert and focused overall. And the no cameras in the chamber fact means that the competing accounts cannot be resolved by direct video evidence. On the legal picture, the skeptical questions from justices at oral argument do not predict the final ruling. Justices are known to play devil's advocate during oral argument, asking hard questions of both sides to explore the weaknesses in each position rather than to signal their vote. A bruising argument does not necessarily produce a loss. Some of the most skeptical oral arguments have been followed by decisions favorable to the party that received the skepticism, and the administration will argue that it is making a serious and legitimate constitutional argument about the scope of the 14th Amendment citizenship clause that deserves a full merits hearing rather than being dismissed as obviously wrong. These are real arguments. The oral argument doesn't predict outcome point is a genuine caveat. The serious constitutional argument point has genuine legal scholars who have made versions of the administration's position. These deserve acknowledgement. But here's what those arguments run into when you apply them to the specific documented situation. The accounts of eye-closing and waning attention came from multiple reporters at multiple outlets, including the conservative-leaning Washington Examiner and Wall Street Journal, outlets with no incentive to exaggerate unflattering coverage of Trump. The Fox News acknowledgement of eye-closing, even while characterizing it favorably, is itself evidence that the behavior was documented widely enough that denial was not the available spin. And the skeptical questions don't predict outcomes caveat, while technically accurate, runs into the specific fact that the skepticism came from across ideological lines, from justices appointed by Republican presidents who might be expected to be more receptive to the administration's reading. Skepticism from the liberal bloc alone would be unremarkable. Skepticism from across the bench is a specific signal that the argument is struggling with the full court rather than just with its expected opponents. And 100 years of precedent supporting birthright citizenship is a specific legal obstacle that makes the constitutional argument genuinely difficult in ways that the devil's advocate explanation does not fully resolve. Trump became the first sitting president to attend Supreme Court oral arguments when he appeared in the chamber for the birthright citizenship case. Multiple reporters, including those from conservative-leaning outlets, described him as occasionally closing his eyes and having his attention appear to wane during the argument. Fox News acknowledged eye closing while characterizing him as alert and focused overall. The White House said he was listening attentively. There are no cameras in the chamber to resolve the competing accounts. The hearing itself was described by attendees and reporters as bruising and a disaster for the administration's position, with justices across ideological lines pressing the government's lawyer on how the birthright citizenship restriction could be squared with more than a century of constitutional precedent. The pattern connects to the falling asleep clips we documented previously. The legal picture connects to the judicial constraints thread we have tracked across the entire series, and the combination of unprecedented presidential presence, reported attention lapses, and skeptical justices in the most constitutionally fundamental immigration case of the second term produced the specific moment that encapsulates two of the most significant second-term vulnerabilities simultaneously: the physical presence and energy questions, and the legal argument failing in court reality. The case is still working through the courts on immigration detention, on the use of the Alien Enemies Act, on the APA challenges to executive orders across multiple policy areas, and on the war powers questions connected to military actions. All of these are in various stages of litigation that are going to produce additional rulings and additional confrontations in the months ahead. The Supreme Court birthright citizenship hearing is the most visible single moment in an ongoing legal battle across multiple fronts. And each ruling, each emergency injunction, each appellate decision adds to the accumulated picture of an administration whose most ambitious policy moves keep running into the constitutional limits that the judicial branch is enforcing. The documented image from that day in the Supreme Court chamber will linger in the political consciousness for a long time. A president who showed up to make history and instead became the subject of a story about attention lapses during a legal defeat. The unprecedented attendance was supposed to demonstrate strength. It ended up demonstrating vulnerability in the most visible possible setting. And that pattern of intended strength producing documented weakness is the thread that runs through so much of the second-term story we have been tracking. The birthright citizenship case will be decided in due course, and the ruling will have enormous implications for the administration's immigration agenda. But the image from the argument, the combination of the unprecedented presidential presence, the reported attention lapses, and the legal setback, is already part of the permanent record. It is already shaping how the public understands this moment in presidential history, and it is already contributing to the accumulated picture of an administration whose reach keeps exceeding its grasp and whose most ambitious projects keep running into the constitutional limits that the system was designed to enforce.